Hello everyone, welcome to the Hampton Law Firm. I'm Jeff Hampton with the Hampton Law Firm, and I want to talk to you for a few minutes today about a subject matter that is brought up on occasion where a client will ask me, hey Jeff, listen, I've been arrested for a domestic violence charge. What's this diversion program option? And is it a good fit for me? We're doing a series of videos about domestic violence and just some of your rights so that you know what to expect if you're facing a domestic violence charge. And I thought it was important that we cover just some very general information about the Tarrant County Domestic Violence Diversion Program. I want you to know technically, or from a strategic standpoint, I usually see this as a Plan B option, not Plan A, but usually as a Plan B option. Let's talk about it and let's look into it. By the way, if you stick around to the end of the video, I will give you a free ebook, What to Do If You Have Been Charged with a Domestic Violence Charge in Texas. And I hope if you like what you see in here today, please don't hesitate to like the video here and to subscribe to our YouTube channel. All right, let's jump right in. Domestic Violence Diversion Programs. Now, why would you even consider it? Well, the only reason to even consider a domestic violence diversion program is that because technically it is a way to get your case dismissed. All right, now it's a year-long program. There's a lot that's involved in it. We'll get into it here in a minute, but before you even get into talking about the program, you need to begin to ask yourself, am I even a candidate for the program? We're going to talk about some of the things that sometimes disqualify people for consideration from the program. And so here's the benefit. If you do get into the program and you complete it, your case is dismissed and you are eligible to get the arrest and the entire case expunged from your record. All right, let me go over some of the qualifications. Number one, in order to be eligible for the program, it must be partner-on-partner violence. Partner-on-partner violence. Number two, you must not have any current or pending protective orders, violations of protective order that are out there, no current or prior violations of protective orders. Number three, it must not be a stalking charge. Stalking is not considered for the diversion program. Number four, you must not have any open warrants or any other charges out of any other counties that's sitting out there that you're litigating at the same time. Number five, no separate pending charges, kind of out of the same vein there. Let's see, 6 is no prior history of being part of a diversion program. Can't be a part of a diversion program in the past. Number 8, commitment to completing the program requirements. What would that be? Well, let's talk about that. Usually what they'll do is they make you report, you have to check in, you usually have to be a part of what's called a PAID program, which that's a 26-week class. You're talking about usually 6 months of classes that you go to that involve some pretty intensive domestic violence counseling that's involved. You have to also not pick up any new cases. You have to make sure and keep your nose clean during this period of time. Now here's the risk on it. You're having to do a plea before the judge in order to be a part of this. And if you violate during the terms and you don't complete the terms and conditions of the program, you've done a plea before the judge. It puts yourself in a very difficult position as far as being able to litigate the case, okay? So then finally, consent, here's the big one that really kicks, is that consent is required by the alleged victim involved in the case. So if the alleged victim does not agree for that person to be involved, for the client to be involved in the program, they can't even be considered for the program, all right? Now, like I told you though, upon completion of this domestic violence diversion program, the case is dismissed. So that's the benefit to it, all right? And although there's a mandatory waiting period for the eligibility to be able to get it expunged from your record, you do still have the eligibility. You will be able to get it expunged from your record. If it's a misdemeanor, you'll have to wait that 2 years, the 2-year waiting period before you can get it expunged from your record. Now, any reasons to be concerned about this program? That's the question everybody always asks me. Is it really a good idea? Are there reasons to be concerned? Well, maybe. Understand, like I said earlier, you will have entered a plea before the judge, a plea of guilty before the judge in front of the court, and the program can be, they ask a lot of you when you're a part of this program, and there's a little bit of unpredictability there. If things don't go well in the program, you're not going to be in a good place because you've already done a plea before the court. And I'm going to just be frank with you from just a pure maneuvering standpoint, strategically, At the Hampton Law Firm, I only suggest this to clients as a plan B. It is not our number one option when we look into defending a domestic violence case. Because I want you to understand, let's say the facts of a particular case involve a high risk of losing in a jury trial, or maybe there's some facts that are not as favorable to our side. This is one of these options that we take a look at and we look into, because the ultimate goal is to be able to get it dismissed. But let's just say this, one of the things that comes up is, what if you've got a case where there are virtually no visible injuries? What if you've got a case where the alleged victim does not want to testify and has provided an affidavit of non-prosecution? Well, in that situation, we're not talking about this option at all. We're looking to push to do all that we can to get the case dismissed through some of the other traditional means. I encourage you to go back through some of my other videos. I talk about the affidavit of non-prosecution and speak a little bit about that as a way to be able to potentially get the case dismissed. All right, so my point is, this is a plan B. All right, but I think it's important to know about the plan B involved in a domestic violence defense and to know exactly what options are available to you. All right, I hope you've enjoyed what we talked about here today. If you need some specific questions answered about your domestic violence situation, or maybe just general law questions about domestic violence law, give my office a call at the Hampton Law Firm at 817-877-5200. If you have some questions, don't hesitate to post some comments below in the YouTube video section there, and I'll be glad to get back to you on it. If you've liked what you've heard today, like the video and also subscribe to our YouTube channel, all right? Now, I promised you, if you stuck around to the end of this video, I'd give you a free resource: what to do if you've been charged with a domestic violence crime in Texas. All you got to do is click the link right down here below, fill out your email information. I'll be glad to send it over to you. Hope you've enjoyed what you've heard today, and look forward to seeing you on our next video. Take care.